Good day, everyone, and thank you so much for taking the time with us today. This is really going to be a great session, and I know if you're feeling any way that I am, or the same way I am, this year, 2024, feels like I've been shot out of a cannon. Like, I can't even believe that this is the first week of February. We're going to have the first day of February in a couple of days. It's just unbelievable how rapidly things are changing, and just how rapidly things are changing in general when we consider all of the dynamics that we have to deal with in the workplace. So again, we thank you for taking the time. And as many of you know, because I know that for many of you, this isn't your first Williams HR Law LLP Year in Review and Trends to Watch webinar. We do this as a kickoff for each of you to update you on the key HR law developments that occurred in the year prior and to put key workplace trends on your radar. So for those of you who I haven't met, I'm Laura Williams, Managing Partner of Williams HR Law LLP and CEO of Williams HR Consulting, Inc. And I can say, given what I do by day as an employment lawyer, workplace investigator, and corporate educator, I can confidently tell you that these past years have been so critical for employers and HR to stay on top of the rapid shifts and changes that have impacted and altered the workplace. In our work with hundreds of organizations across industries and sectors intensely over the past few years, we can validate the stats, facts, and trends related to what has become the new post-pandemic workplace, an environment that has business leaders, people leaders, HR, unions, and employees in a swirl, contending with issues that are hard to navigate and opportunities that we haven't quite figured out how to leverage. From the mental health crisis we're experiencing, the burnout and depletion that employees and specifically many leaders are feeling, the new modes of communication, learning, and working that have transformed how we interact, engage in, and perform work, and provide client and customer service, novel issues that have arisen as a result of these workplace modes, realities and the dynamics that we're experiencing, including the technological changes that are so fast-paced right now, including the integration of AI into the delivery of work product. Workplace culture has morphed, and trust, particularly in leadership and HR, has eroded. We're also contending with shifting workplace dynamics and demographics with an aging workforce and a new workforce as a result of increased immigration. Also, employees are much more savvy regarding their entitlements and are aware of the fact that legislators and decision makers are sympathetic to the realities that they have to face. And, this has led to more challenging and pressure testing of workplace decisions made by leaders and more close scrutiny and scrutinizing of employer decisions and holding them to their obligations. This also includes in the areas of fairness and equity within the workplace. And as the workplace continues to evolve and shift, courts, tribunals, and legislators are trying to keep pace to level up the laws that may not adequately address the complexities of our time. And for those of you who are attending, this is why we do this Year in Review and Trends to Watch webinar year over year, and why it's so important in our current workplace climate to attend and to hear of how things have been shifting and changing. We want to help you identify the tricky issues and equip you with some of the practical and actionable ways to proactively address these issues in your workplace. So you will be hearing from our lawyers. I know many of you know certain of them, from Joel Smith, Alexandra Pressy, Faraz Paranji. You'll also be hearing from Ni Huyn, as well as Ingrid Wabolo. And what they've kind of cooked up for us is what we've identified to share with you this year. And I also want to acknowledge in particular their hard work in preparing the content that they'll share. But also, I want to recognize the hard work that our other lawyers and support team members have contributed to putting on this webinar and who are behind the scenes ensuring everything runs smoothly. So in terms of the topics we're going to cover, and I would say our mission should we choose to accept it, we're going to cover the trickiest of the tricky developments that we know you're contending with, including those related to accommodation, the legislative updates that have occurred during the last year, the ever-evolving complexities as they relate to workplace investigations, the increased liabilities that relate to conducting terminations and employer bad faith conduct, and finally, the complexities that have arisen from our new hybrid working realities. Note that the topics we'll cover are also featured in our Year in Review and Trends to Watch newsletter and the weekly blogs that are featured on our website, which you can access at williamshrlaw.com. And finally, if you have any questions regarding the topics covered during the webinar, please write them in the Q&A box. We want to hear your questions, and we're going to try to field as many as we can during the webinar Q&A time that we've allotted at the end. But, you know, as we monitor the Q&A box, I may sneak in a few for our speakers as they end our segments. So let's kick off our topics, starting with one of the trickiest areas for most employers, dealing with accommodation requests and needs within the workplace. Alex, over to you.
Thanks so much, Flora. And indeed, accommodation has been and continues to be tricky terrain for employers. As a result of the current climate, particularly the mental health crisis and the employee awareness of entitlements that Laura mentioned, employers are facing accommodation requests that are much more complex than they've ever been before. And when things get particularly complicated, we find it's always best to go back to basics, which is why it's good to start with a refresh on some foundational principles we've outlined here. Because in our experience, based on the multitude of accommodation-related matters we're asked to assist with, when the rubber meets the road, employers, people leaders, and HR professionals can sometimes forget some of the key things they have to do, which is easy to do because there are a lot of moving parts to accommodation. Now, accommodation, as many of you will know, arises most frequently in the context of disability, creed, family status, sex, particularly pregnancy, as well as age, gender identity, and gender expression. But today I'm going to focus on disability specifically because of the recent developments and trends we've seen in the last year. And disability covers a broad range and degree of conditions. Some are visible conditions, physical disabilities, and some are not visible, such as mental health disabilities or addiction. But under the code, organizations are required to provide accommodation for any of these to the point of undue hardship. And that's a really high threshold. That said, there are limits, which are really important for employers to keep in mind. Employers are not required to allow an employee to work in a way that would harm their health and safety or the health and safety of others in the workplace. They're not required to create previously non-existent duties. They're not required to assign non-productive duties permanently. They're not required to accommodate where no accommodation is available that allows the employee to actually fulfill the essential requirements of their role. And they may not be required to continue engaging in accommodation efforts where the employee refuses to cooperate. And that's really important to remember that employees have duties too. We often talk about the duties of employers and what employers have to do and liabilities for employers, but employees have a duty to cooperate in the process, provide the type of information that's required for employers to fulfill their obligations. And for those employers who are in unionized workplaces, it's also important to note that unions can't obstruct these processes. So there's an obligation there as well. And the duty to accommodate is triggered when an employer becomes aware of a disability or an employee requests a disability. Employees might not always be forthcoming because of fear or stigma associated with a particular condition. So this duty to inquire may be triggered, but what you're inquiring about, it's important to keep in mind, is always things like medical limitations and disability accommodation and prognosis information, not the diagnosis. So you're not asking what the condition is, but what are the effects and what's the prognosis information. And the duty to accommodate is informed by three key principles: respect for dignity, individualization, and integration and full participation. So what this means is that accommodation is really a process and a matter of degree. It's very, very context specific, and it's in no way a one-size-fits-all approach. When you're accommodating, you have to keep in mind both the procedural and substantive duties. So the procedure to assess an accommodation is just as important as the actual accommodation that's ultimately put into place, which means that how you go about the process is just as important as what you ultimately do. So if you haven't demonstrated that you fulfilled that procedural duty, you might actually end up being in violation of the duty to accommodate properly, even if it turns out that there was no way to reasonably accommodate the employee in the circumstances. And that's actually a really good segue to the last foundational point I want to make, which is that it's reasonable accommodation you're looking for, not perfect accommodation. The goal and the obligation is the most appropriate accommodation short of undue hardship, which isn't necessarily going to be what the employee wants and would most want to have. So given those foundational concepts, we've identified some key trends and developments based on the situations we've encountered in our practice. And the first development I want to cover with you has to do with the assessment of when undue hardship is reached. So undue hardship, as I mentioned, is a high threshold, but it can be met where it's not possible for an organization to meet its health and safety requirements while accommodating an employee. And the case that's mentioned here is outlined in more detail in our newsletter and on our blog, but it relates to a situation where an employee provided medical documentation to demonstrate that she couldn't wear a mask and comply with an employer's mandatory mask policy because she had a phobia. In this case, the arbitrator found that accommodating this would have been undue hardship because of health and safety considerations and also the public health circumstances at the time. Undue hardship can also occur in cases like we've had in our practice where other staff are feeling impacted by whatever is going on with the employee who needs an accommodation. That is to say, sometimes others in the workplace are really scared for their own well-being. This might be because the employee who needs an accommodation is behaving erratically or even aggressively. We had a situation where an employer came to us for advice because they really wanted to help the employee who clearly was going through a crisis of some sort, but they weren't sure how to do this while also making sure that they were taking care of their other employees. And this can be really tough because it may not always be possible to accommodate an employee in a situation like this. And these employers who want to lead with compassion and care for their employees have to make sure that they're doing it for all of their workforce, not just the employee raising an accommodation need and assessing, in these circumstances, given the impact on the workforce, is there actually undue hardship here? Another development that employers want to keep their eyes on relates to requesting information. So again, this case is outlined in more detail in the newsletter and on the blog, but it deals with a situation where an employee refused to comply with a mandatory vaccination policy and then conveniently at the time when he would have had to face consequences for this non-compliance, provided a vague medical note saying he was totally disabled and off work for medical reasons. In this case, given the vagueness of the documentation and the suspicious nature of the timing, it was determined that it was appropriate for the employer to be really, suspicious of the true reason for the leave and push for further medical information. And this is something that we see a lot in our practice. For example, we had a situation some weeks ago where an employee had asked for an extended leave to go visit family internationally, and the employer, despite best efforts to give them that leave, wasn't able to approve it for operational and staffing reasons. Now, the employee, went for what was supposed to be a 2-week vacation instead of a 6-week time off that they had requested, and sent back a doctor's note from another country on a template in another language, which just generally said the employer requires support, didn't specify the need for a leave, didn't specify a duration, and provided contact information for a doctor that seemed to be suspect. In that situation, an employer would be well advised to push back and say, well, this doesn't actually say what it is that you're telling me. You're saying you need a leave. The doctor's note doesn't say that. And also we have more questions, and request additional information that actually allows you to fulfill your duty to accommodate. And finally, we want to flag the trend that employers are increasingly navigating complex accommodation situations related to mental health and the mental health crisis that Laura identified. And when you are trying to accommodate in good faith to your best efforts an employee with profound mental health needs, it can be quite difficult. So for example, had a situation where an employee was on leave, but wasn't providing any medical information. The employer was reaching out, and not getting what they needed to even satisfy this procedural obligation. Eventually, after time passed, after multiple outreaches to the employer wanted to take the position that the employee had abandoned their employment. They reached out, they provided last chances. Ultimately, they were poised to end the employment relationship, and then the employee resurfaced. At that point, employers have a tricky situation to deal with because they have to determine, could that decision actually stand up? Or was the employee truly not in a position where they were actually able to respond, able to engage? And if they made a complaint to, say, the Human Rights Tribunal of Ontario, would the tribunal find, as they have in some cases, that an employee who is in a situation like this where they're experiencing trauma or crisis may not be able to be held to those standards that otherwise they would be expected to uphold. So with all of these, the tricky terrain, the developments and trends, we've identified some key strategies to address where we've seen in our practice that employers tend to trip up. I'm going to go through these quickly as well. The first is to take accommodation requests in good faith, which applies across all accommodation situations. But in the current climate, what we've seen is sometimes employers don't feel able to do this because of who's making the request, particularly when it relates to an invisible accommodation need. And perhaps the employee is not a great performer, they're a bad actor in the workplace, and the employer could be suspicious, sometimes for legitimate reasons. But what they have to keep in mind is that really the accommodation request could be legitimate, and because of the procedural duty to accommodate, you have to make sure that you're still asking the right questions, getting all the information before you jump to any sort of decision, because otherwise it could result in significant challenges and damages ultimately against the employer. You also want to make sure that you're always requesting and insisting on clear, thorough information to support the accommodation need, whether it's medical information or other related information. Sometimes something may seem to be obvious, as in our example of an employee who's experiencing a crisis, or you want to be considerate and take them at their word, particularly where they do seem to be in distress. But if, for example, an employee is saying, I really can't work, I need leave, and the doctor's note says, well, the employee needs some modified duties, which, we're not, none of this is fiction. These are situations we've encountered and they happen often. You're going to want to push back and get solid information you can rely on. You also want to make sure that you're assessing undue hardship always based on concrete evidence. Employers should consider concrete evidence and avoid concluding there's undue hardship based on suspicion alone. Like I said, it's a very high threshold, so if there is some sort of complaint that arises, you're going to want to ensure that you can demonstrate proof to support whatever decision you ultimately made and implemented. And you're going to want to make sure that you develop or update your accommodation policies and procedures, because having a very clear and thorough accommodation policy is going to help you preempt these types of issues that can arise. If you set out clear expectations, if you make it clear that employees have obligations too, then in the event that they're deficient in providing what they need, they're not cooperating with the process, you can tie and tether that non-compliance to the policy and push for the things that you need to fulfill your obligations. And finally, you want to make sure that your frontline managers are trained. A lot of issues in our practice that we've seen are created where frontline managers don't identify or appropriately respond to an accommodation need or request. HR or senior leadership may be well equipped to deal with these issues, but if it never gets to them, then there's not much they can do to help. So with accommodations really being, and as we expect to continue to be, quite tricky terrain, employers that implement these strategies, we think, will be really well positioned to address any accommodation challenges in 2024.
Well, Alex, thank you so much for kicking us off. And the topic that you tackled is indeed one of the trickiest. And we know this from the questions we get from employers day in and day out, and also when we're in rooms conducting corporate training or education. Always, I find, when we talk about just general workplace themes, accommodation is the one that employers are most concerned with, because they want to, in a climate where, there's such a focus on wellness, they don't want to get it wrong. And a lot of employers want to be compassionate, but, dealing with, perpetual absences or not feeling like you're fully informed is something that really can be tricky when you also have the demands of, running a business or ensuring that operations continue. So before, we move on to the next theme, I just want to camp on, you gave it as an example, but this is the first question we always tend to get from employers. And that's when employees are on protracted leaves of absence related to accommodation, how long does an employer have to wait until they can end the employment relationship? And the follow-up question to that is always, at what point does it become frustration of contract?
And that's a really good question, which, unfortunately, I have to start with the frustrating lawyer answer that you're familiar with, Laura. It depends.
It depends.
It depends, because like I said, accommodation is a matter of process and degree. So it's really going to be very specific in the circumstances. It could be that there is an opportunity fairly quickly and, not in a day or two, but relatively quickly in the lifespan of an employment relationship to take steps to say, well, we can't accommodate. And if the employee isn't cooperating, isn't responding to you, you may have opportunities to impose discipline or even say, well, you've abandoned your employment. We haven't heard from you. If they resurface, that's another story. Sometimes they don't, which we've also seen in our practice. But if an employee is away on a leave, providing medical information that says that they could get better, has a relatively positive prognosis, which we know the doctors tend to be wary of providing the clear type of prognosis that you would need to say that an employment contract has been frustrated, that the employee isn't going to be able to return in the foreseeable future. It can be a lengthy process. And there's no specific magic number. It really depends on what's going on with that employee, that employer, and that particular relationship.
Well, thanks so much, Alex. I just intentionally wanted to circle back to that question because I know it is one of the questions that tops the charts for employers. And I know for those of you in attendance that I know you have questions about accommodation, so don't be shy. Populate them in the Q&A box, and we'll try to get to as many as I mentioned before at the end of the webinar. All right, Alex, thank you so much. And on to you, Nii, to regale us with what's new on the legislative update front.
Thank you, Laura, and good afternoon, everyone. So as Laura mentioned, there are a significant amount of changes, and there continues to be changes in the workplace environment across all industries. Legislators are trying their darndest to keep up, and so we have still continued to see changes in legislative updates rather in 2023. As Laura mentioned, these changes favor employees. They're meant to provide employees with further entitlements and protections really in response to those changes. So it's important for organizations and employers to keep their ear to the ground and really try and anticipate where trends may go. There are many legislative updates in 2023. For the purposes of this webinar, I'm only going to be focusing on a few key updates. But as Laura mentioned, we regularly provide legal updates through our newsletter and our blogs if you want to know more. It's also going to be important for organizations and employers to understand that the legislative updates are really only dealing with the minimum standards and the minimum entitlements. So there may be reasons, for example, business reasons, cultural reasons, reputational reasons, that an organization may want to provide employees with more. And that's something, for employers to consider while we go through the legislative updates. Another thing I want to ask employers to do while we consider these changes and how they might affect your organization, consider the why when it comes to implementing your own changes in response to these legislative amendments. Because the why, as you've heard from us many times, is very key to really making sure your employees get it and follow everything. So let's start with the amendments to the Canada Labor Code. So this is our first example of increasing statutory entitlements for employees, and these are upcoming changes. So there are a number of amendments to the Canada Labor Code, but the key one that I'm going to be focusing on today is about the notice of termination entitlements for federally regulated employees. And those are employees, for example, they work in banks, telecommunications, broadcasting, transportation, these types of jobs. So the Canada Labour Code, it's similar to the Ontario Employment Standards Act. It's the backbone that provides the minimum entitlements and outlines the minimum standards for, in this case, federally regulated employees. The ESA really just covers the provincially regulated employees. So on February 1st, 2024 of this year, rather, the Canada Labour Code will significantly change notice of termination entitlements for these federally regulated employees. It's going to introduce what we have for provincially regulated employees, a graduated notice system. Right now, currently, there's only a blanket of 2 weeks of notice or termination pay for employees who have been in continuous employment for 3 months. So getting rid of that blanket 2 weeks, adding a more graduated system. The scope of this change is going to be somewhat limited. The nuance, the difference between provincial and federal, for federally regulated employees, they can't be dismissed without cause unless they fall under very specific narrow circumstances that are outlined under the Canada Labour Code. So it doesn't happen too often, but it can still happen. And then as with the Employment Standards Act under the Canada Labour Code, there's also specific entitlements for group terminations, and that's something to look out for as well. So it's important to know, just like under the Employment Standards Act, the statutory termination pay and the statutory severance pay are different concepts. They're different under the Canada Labour Code, and these amendments to the notice and termination pay entitlements, they do not affect the severance pay requirements under the Canada Labour Code. And then now, moving on to the next one, we're going to be talking about amendments to the Employment Standards Act as another example of how legislators are trying to protect vulnerable employees. The Working for Workers Act 2021 introduced several changes to the Employment Standards Act, and in particular introduced a licensing regime for temporary help agencies and recruiters. So July of last year, temporary help agencies and recruiters were able to begin their licensing applications. Effective July 1st of this year, temporary help agencies and recruiters must have a license to operate in Ontario. And why that's important for employers is that organizations are going to be prohibited effective July 1st of this year from knowingly using or engaging in services from unlicensed temp agencies and recruiters. And doing so can attract some very hefty penalties. So one is a compliance order. To the organization can face prosecution if they knowingly use an unlicensed temp agency or recruiter. And then there are new penalties that are going to come into effect. So for a first violation, you can face $15,000 for using an unlicensed recruiter or agency, $25,000 for a second violation within a 3-year period, and then $50,000 for the third violation. So it's important to really understand these rules surrounding the amendments and, just to make sure you're complying with the new rules and avoiding the penalties that I just listed. For example, even if a temp agency is located outside of Ontario, but they're assigning employees to work in Ontario, the licensing requirements apply. Moving on to the next one is the Working for Workers 4 Act. So we have four of these acts now. So it's another example of legislators' intent to really provide, as I mentioned, further entitlements and protections to the to employees. Right now, it's in its second reading, but if passed, Bill 149, the Working for Workers 4 Act, will require employers to disclose salary ranges in their job postings and to disclose if they're using AI in their hiring or recruitment process. And so pay transparency, it's really aimed to address the tight labor market. There's been a lot of attrition across industries, and employees were needlessly preparing themselves for interviews only to find out that the compensation was well below what they had expected. And so it's to the benefit of the employee. It's also meant to close the gender wage gap. Women still earn less for the same work than men. And that gap is even more pronounced for racialized women. So these are things that the legislators are trying to address. Bill 149 will also prohibit the use of Canadian work experience as a requirement in job postings. It will also prohibit unpaid work trials. And so there will be conditions, restrictions, limitations, expectations that are prescribed by regulation, but that's, again, more to come. It's in its second reading right now. Okay, so let's move on to the takeaways for the legislative updates. So while the trend, as I mentioned, is, legislative updates are meant to provide employees with further entitlements and protections, we do encourage employers to take this opportunity in times of change to look at how to leverage these opportunities and in adapting. And so first, update your employment agreements. For example, as I mentioned, federally regulated employers will need to update or should update their employment agreements to comply with the Canada Labor Code amendments. While permissible without cause dismissals, as I mentioned, are rare. You just want to get ahead of it because the difference is not having a properly drafted termination clause will entitle the employee to common law notice entitlements or termination pay, and that far exceeds what they're entitled to under the Canada Labor Code, or in the case of provincially regulated employees under the Employment Standards Act. So you've heard us talk about it. I will say it again, although legislative updates or amendments are always remind us to look at the employment agreements, review them. Really, this should be done as best practice on an annual basis at the very least, or periodically. And again, this goes to all employers, not just federally regulated employers. To ensure compliance with the licensing requirements for organizations who do use temp agencies and recruiters, you should build into your processes as a requirement to verify the licensing status of temp agencies and recruiters. The reason being, this is something we can see being a simple but expensive misstep for organizations if it's not top of mind. So, get ahead of it and put it so it's top of mind for those involved. And verifying the licensing status of a temp agency or a recruiter can be done online through the Ministry of Labor's online portal and by engaging in the temp agency and recruiter. So 3, regardless of whether ultimately it's legally required, organizations should take stock of their compensation practices. And this is what I was talking about, the posting the salary on the job postings. Even if that doesn't happen, take a look at your compensation practices. The reason being, we're seeing more and more pay equity issues and equal work for equal pay issues coming to the forefront. It might feel onerous, but it's a good thing. Employees are going to talk about their compensation regardless of how organizations might want to control that. And so a way to curb, curb that issue or make it not an issue is don't give them something to talk about. Be intentional about your compensation practices. 4, be careful of what you do or do not publish on job postings, given the intended changes from the Working for Workers for Act. And then be careful about the questions you're asking during the hiring process. Make sure you're not, again, asking questions about Canadian work experience. Instead, use this as an opportunity to reevaluate your questions, consider what it is that you really need and want from your candidates, and then draft better questions from that. Are you looking for certain experience with certain software, certain transferable skills? These don't have to be gained through Canadian work experience, and it really is better to specify what you need. It's more likely you're going to get what you need if you be more specific in those terms. Also be careful about using AI. AI is great. It can help with a lot of things, but it can also, you might inadvertently create discriminatory hiring processes or might inadvertently share personal information. AI is well known to have biases because it's trained from specific data sets. And candidates will want to be reassured that their personal information isn't going to be included on online data sets without their permission. So that's something to think about, and something to think about how you're going to reassure candidates if you are using AI in your hiring processes. And then finally, as I mentioned earlier, it's important for organizations to look out for developments, anticipate trends, where trends may go. For example, the Working for Workers Act 2023 included an amendment where the Lieutenant Governor and Council can create regulations to prescribe what information must be provided to prospective employees and when that information has to be provided. And so it hasn't been rolled out yet, but it's something to watch out for. And it's important to know what you would want to include in your offer letters and employment agreements, and just turn your mind to that. And then WHRL has, as I mentioned, a newsletter to complement our webinar topics. We also have our blogs, and where we post our legal updates regularly. And I just wanted to say, if there are others from your organization that you want to include on our mailing list, please let us know, and then we'll make sure that they're on our list. And I'll pass it back to Laura.
Thanks for that, and thanks for giving the reminder about the blogs, et cetera, because there are so many changes, and a lot of changes on the legislative development front that have occurred and that have to occur to keep up with, as I mentioned from the outset, and we've heard from both you and Alex, that things are changing and getting more complex. But one thing I will say why a lot of employers need to kind of stay on top of the developments as it relates to the legislation is that we're dealing with a time, an era where a lot of the legislative developments, as you mentioned, are employee rather friendly. I mean, even look at the names of them, the Working for Workers Act, right? So, employers really need to ensure that they stay on top of the legislative updates so they're not offside or creating unwittingly, risks and exposures that relate to non-compliance. But before we move on, I wanted to just camp on one thing in particular that you mentioned, and that's a development that hasn't happened, but that is perhaps coming to a town near us soon, and that's pay transparency. And a lot of employers have been bristling at the prospect of having to comply with this legislation. And I can tell you in talks that I've been doing, or even media reaching out to gain comment, that this is something that's very topical, and it's topical because it is of concern. And we know when you've covered the benefits of pay transparency legislation for employees and for candidates, and it's generally believed that it will have some significant impact, including, as you mentioned, in addressing and perhaps narrowing the gender pay gap. But is there any upside of this legislation, should it be enacted, for employers?
Good question, Laura. And employers, they hear that and they do think it's going to be intrusive, as you were indicating. As I mentioned, pay equity issues and equal pay for equal work issues are coming more and more to the forefront. The more information is coming to light. Sometimes when you shine a light on something, you really see everything. And the big reason for disputes happening or complaints or claims, employers haven't been turning their minds to their compensation practices. And again, this is an opportunity for employers to be intentional about it, to just get ahead of the issues. It can also help with retention, making, especially in this day and age where, as I mentioned, there's a tight labor market, things are getting quite competitive. Being intentional about how you're going to retain your employees. And for the employers who might be concerned, they're unable to meet employee expectations, whether new candidates or existing employees who are going to also be affected by this. It's an opportunity for employers to highlight other ways that your organization values your employees and brings value to your employees. For example, employees care more and more about flexibility, unique benefits, more vacation, excellent workplace environments, and cultures, opportunities to advance. The list goes on. So it's not just about compensation in one aspect. Turn your mind to compensation and benefits as a whole. And yeah, it'll help get ahead of the issues and help with retention, I'd say.
Thanks a lot for that perspective, Nee, and also for regaling us with some of the key legislative updates that we need to be aware of. So with that, here's another gear shift to an area that is really a chart topper for many employers as well, and that's the area of workplace investigations, and particularly where you're conducting investigations internally. So as many of you know, our firm conducts workplace investigations, and also we provide advice and guidance to employers that are conducting their internal workplace investigations. And from that lens, we can tell you with the utmost confidence, as I'm sure many of you have experienced in your organizations, that the number of complaints that are escalating to workplace investigations or that require investigations has been at a level that we haven't seen before. And, part of it comes from some of the trends and themes that we discussed, such as the focus on justice, social justice and fairness, and also how we have changed the dynamics of how we work and interact together, which leads to certain types of conflict at times and misunderstandings, which are very easy to have when you're communicating with people in 2D and more electronically these days, as well as virtually, of course. So we're in a climate where organizations need to level up their understanding of around the complexities of workplace investigations. And I'm going to turn it over to Ingrid Bobo, who's going to tease out some key themes that need to be on your radar so you can navigate investigations within your workplace. Over to you, Ingrid. Ingrid, you're going to have to take it from the top because I knew that this was going to happen at some point. I thought it was going to be me, but you're on mute.
Oh no, that's embarrassing. I'm so sorry. I forgot that there was an unmute button. Let's take it from the top. I was sort of, greeting everyone and thanking you for joining us. But, as Laura said, in recent years, we have seen employees come forward with all manner of allegations. And if we could just move on to the next slide. Some complaints are more difficult to investigate than others. So, as you see here, there's sort of a spectrum of complexity in investigations. So, for example, a complaint can involve recent, fairly straightforward allegations. Other complaints can involve historical allegations that span decades and involve a huge number of potential witnesses. And in some cases, they can fool you. So what begins as a seemingly straightforward investigation can unravel into a far more complex scenario as the process goes on and new information comes to light. So there's a spectrum of complexity for sure, but processes, again, can surprise you as they unravel, and generally speaking, investigations have become more complex. And part of that is due to a paradigm shift that we've observed in how courts and tribunals assess investigations. It's no longer a matter of checking a box to see whether an investigation has been conducted. Courts and pressure testing every little detail. And what's notable about how the case law has evolved over the past year is that the scrutiny is becoming much more technical. So for example, one issue that we'll get into later is how the evidence is assessed with respect to the credibility and reliability of investigation parties and witnesses. But suffice it to say for now is that along with this increased scrutiny, the stakes are higher than ever, with increasing liability and penalty limits for OSHA violations, which would of course include the failure to address workplace harassment through a proper investigation. And if you could move on to the next slide, please. A lot of employers do fall short when it comes to investigations. Many recognize the complexities that investigations involve, perhaps, and are trying to find ways not to investigate at all. But the thing is, investigations are, not only required, but they're valuable. They can play a key role in justifying HR decisions. Take the Dove v. Destiny decision that I cited here as an example. In that case, the employer was able to rely on an investigation to justify their decision to dismiss an employee for cause. So the employer had suspected the employee of moonlighting and had asked the employee to participate in a third-party investigation. The employee refused and she was later dismissed for cause. And at trial, the employee tried to argue that she'd been dismissed without any formal warnings about her performance. But the court saw it differently. The court found that the investigation itself was sufficient warning to the employee that her job was in jeopardy. And the court considered that and ultimately, coming to the conclusion that the for-cause dismissal was justified. And the Dove decision really shows us that investigations can be the difference maker in how courts view an employer's decisions. And unsurprisingly, when an employee or their counsel is attacking a decision that's been made related to investigation findings, they often go after the investigation process itself, because if you take the legs out of the investigation, you can undermine the decision. And what's even more concerning is that the increased scrutiny on faulty investigations can lead to significant damages. So, for example, in the Central City Brewers decision, the court awarded aggravated damages to an employee after it found that the investigation the employer had conducted was adversarial and biased, not my words, those are the courts, and amounted to a breach of the employer's obligation to treat the employee fairly and in good faith. So, it's very key for employers to get investigations right, and it's tricky, right? Because technical aspects such as credibility and reliability assessments, as scrutinized by the court in the recent Rubin Tomlinson case that I've cited here, are now very much under the microscope. And just very briefly, credibility refers to the honesty or truthfulness of an investigation participant, and reliability refers to their ability to accurately recall the events at issue. And assessing the credibility and reliability of the parties often becomes very key when you're faced with a he said, she said situation, because they help you draw reasonable conclusions about which version of events is more probable. And these assessments are, difficult to do well in and of themselves, but there are sort of additional complexities that might come to bear on that already complex assessment. So, for example, it might be necessary to consider how a trauma-informed approach can inform a witness's credibility and reliability. In a recent investigation that we conducted, we encountered a complainant who presented as having experienced significant trauma, for example, and who was making very strong allegations about the respondents. We were very careful in recognizing the impacts of her trauma on the evidence. So, for example, in terms of her credibility and reliability, we considered how that trauma generally diminished her ability to perceive the details of certain incidents, and how it impacted her perception of other people's conduct and how reasonable those perceptions were. We also really emphasized that although she was credible in the sense that, she sincerely believed everything she said and she wasn't being intentionally dishonest, her accounts didn't bear out when reconciled with other witness and documentary evidence. And a large part of that was, again, due to the impact of her trauma, which we recognized, very clearly in our assessment of credibility and reliability. And by the way, all the cases that I've cited here, the Dove case, the Central City Brewers case, the Rubin Tomlinson case, these are decisions that we've written extensively about in our blogs and in our most recent newsletters. So I'd encourage you to check those out if you're curious to hear more. Let's proceed to the takeaways. So, in light of these developments, it's really imperative to implement and socialize key policies. The policies will be invaluable in setting up clear expectations for the investigation process, which can help make it easier on the investigator in terms of minimizing or preempting any sort of process-related questions or issues that might otherwise bubble up. It's also important to develop procedures to train your internal investigators on all of the little bits and bobs that make up an investigation process. We discussed credibility and reliability assessments, which can become very technical. These are more niche aspects of processes that many aren't trained up on or even aware of, but are again really foundational to defensible investigation findings, and are absolutely important to include in a comprehensive sort of training program. We've reviewed, created, and conducted many of these programs ourselves, and out of that work, we've developed a sort of gold standard to help organizations determine how they can best establish sustainable and comprehensive investigation processes. And when it comes to training, a focus on frontline managers is key. This is because they need to know how to triage and complaints and when and where to escalate them when they're brought. But also, as you all likely know, the duty to investigate harassment under the OSHA is triggered on the employer becoming aware of an incident and isn't necessarily, complaints driven. So frontline managers have to know how to proactively detect and identify incidents that may need to be investigated. And finally, when it comes to conducting investigations, there's a critical decision to be made at the outset. Given these increased complexities and potential penalties, employers really need to determine whether to outsource or conduct investigations internally. When you're doing that, it's essential to take a really realistic look at your internal capacity and ROI, and be careful not to assume the scope and complexity of an investigation process. For example, we recently supported an employer who was conducting an internal investigation. They had a small HR team, but they didn't anticipate issues because the allegations seemed relatively straightforward. But it was a bit of a Pandora's box, right? And there were challenges with witness cooperation, delays, evidence spoliation, process disputes, and counter allegations that escalated costs and efforts significantly. And this client, having worked closely with us regarding these processes, did everything right, even with all of those complexities. But ultimately, the processes just took them forever. And that's what employers don't often think about, just the sheer amount of time that is required to conduct a thorough investigation. So it's essential to, again, take a close look at your internal capacity, your ROI, before making this decision to outsource or keep in-house.
Wow, Ingrid, that's a whirlwind. And again, I know we're just camping for the purposes of this webinar on some of the really key aspects of each topic and theme that employers need to know based on recent developments. But just, practically where kind of the rubber meets the road and oftentimes where the wheels pop off, I wanted to circle back to one of the things that you mentioned regarding the trickiness of assessing evidence and the fact that evidence can become compromised or spoiled. So, I think it's worthwhile just taking a second and just kind of doubling down on this, because oftentimes when you're investigating, it's not clear or intuitive with respect to how, evidence can be compromised. So share with us, in what ways can evidence become less reliable or compromised as a result of how an investigation is conducted?
That's a really great question, Laura. So when we talk about evidence getting spoiled or compromised, there are a bunch of ways this can happen. And it's really frustrating when it does. It's like trying to put together a puzzle when some of the pieces have gone missing. But one major factor is delay. When there's a lag in starting the investigation, it can cause serious issues. People's memories start to get fuzzy and they might not remember the details clearly. And certain information or physical evidence that was available right after the evidence might not be there anymore. Right after the incident might not be there anymore. And, in today's digital world, a lot of evidence is stored electronically. So if investigation participants aren't told to keep their records safe, important emails, messages, or files might get deleted, whether inadvertently or not. And then there's the issue of how the investigator asks questions. If questions aren't asked in the correct way, you might not get the full story, or, you might lead a witness to give an answer that isn't quite accurate. It's like walking a tightrope. You've got to be careful with every step. So ensuring the investigation is timely and that the evidence stays intact and is collected properly to the greatest extent you can is very important. It's all about making sure you're getting the whole picture and that the evidence you gather is as solid as it can be.
Thanks so much, Ingrid. And I'm restraining myself because, your topic is one, like the others, that we could conduct a full day seminar on in and of itself. And also because just of how it's become more complex and scrutinized, which is kind of the theme that cuts through all of the different topics that we've selected for the webinar today. Because again, they're all tricky, which is a great segue to the next topic, which is going to be presented by Faraz Kurunji, who is one of the lawyers at the firm, and he's going to cover terminations and bad faith conduct. And again, this is an area where, again, it's been kind of shifting and morphing over the past numerous years. But one of the things that is really clear and key to note is that exposures for employers implementing terminations in a manner that could attract liability they're increasing and expanding. So with that, I'm going to turn it over to you, Firas.
Thank you, Laura. And hi, everyone. Thanks for joining us. So we definitely have been seeing a lot of terminations, especially in certain sectors. So the tech and financial sectors, for example. Like, I don't think I've gone a full week without assisting an organization with a termination. So what's contributed to this is the pandemic. It's contributing to volatility in the labor market. So many employers have been making desperate hires to meet demand. And now what we're seeing is employers taking drastic measures to reduce the workforce. So I'm just going to provide a high-level overview of some of the key concepts related to terminations of employment and bad faith conduct. So first, it's important to understand that without a written employment agreement that has an enforceable termination clause, an employee is going to be entitled to reasonable notice of termination. In our experience, a lot of employers mistakenly believe that a reasonable notice of termination follows a set formula. That's not the case. So unlike the minimum standards under the Employment Standards Act, reasonable notice, it's a common law concept. And what determines the amount of notice is a number of factors, such as an employee's age, their length of service, the character of their employment, and the availability of similar employment opportunities. So in most cases, an employee's entitlements to reasonable notice are going to significantly exceed their entitlements to termination pay under the ESA. So the next concept I'm going to discuss is the concept of just cause and the related concept of willful misconduct under the ESA. So as you likely already know, a termination can be done on a without cause basis or on a for cause or just cause basis. What many employers don't realize, however, is just how high the threshold is for just cause. So to reach just cause or to meet this threshold, employers will usually have to conduct an investigation first and give the employee a reasonable opportunity to respond to the allegations against them. In cases of misconduct or in cases of incompetence or performance issues, the employer will usually need to give the employee a reasonable opportunity to improve their performance. And the last key concept that I'm going to discuss is extraordinary damages. So when an employee brings a lawsuit for wrongful dismissal or constructive dismissal, the employer is usually going to be on the hook for damages for reasonable notice. However, they could also be on the hook for additional damages in the form of extraordinary damages as a result of the manner of dismissal. So if it's not conducted appropriately, they could be on the hook for what's known as moral damages or punitive damages. So moral damages are damages in relation to an employee suffering mental distress as a result of the manner of dismissal, and punitive damages are awarded to punish an employer's conduct where that conduct is deemed to be deserving of punishment. So all this to say that an employer's liability when dismissing an employee can be significantly more than initially anticipated. So I'm going to discuss some trends and developments now related to terminations of employment and bad faith conduct. The first trend is that termination clauses are being increasingly scrutinized in an employee-friendly manner. So in the decision of Celestini, the Ontario Court of Appeal applied what's known as the changed substratum doctrine. Essentially, the court held that because the employee's duties changed so significantly over time, and those changes were not contemplated under the original employment agreement, the foundation of the agreement disappeared, and it would not be fair to enforce the termination clause in the employment agreement anymore. So this is yet another example in over a decade of case law where the courts have found a reason not to enforce an otherwise valid termination clause. The second trend that we've been seeing is that courts are awarding lengthier notice periods. So previously, Ontario courts have held that there's a general cap of 24 months of notice for employees. who've been dismissed. Now what we're seeing is courts are more willing to exceed that 24-month cap, and they're finding exceptional circumstances in cases that we might not necessarily consider exceptional. So these first two decisions listed here, Lynch and Millwood, these cases involved employees who were in their early 60s, fairly specialized roles, and they had significant periods of employment, so 35 plus years of employment. And they were awarded, in one case, 27 months of notice, and in the other, it was 30. And the reason the court awarded such lengthy notice periods is because the employees in this case, for one, they had specialized roles. And second, given their age, court held that it would be more difficult for them to find alternative employment. And in relation to one of the employees, the court held that because they lived in such a small town where there were sort of limited employment opportunities, it would be more difficult for them to find alternative employment. So that was another factor there. And the third case listed under that lengthier notice periods bullet is the Grimaldi decision. So courts aren't willing just to provide lengthy notice periods for longer service employees. What we're seeing is that they're willing to provide lengthier notice periods for exceptionally short service employees. So the employee in this case worked just 5 months at this organization and was terminated at that time. And the court found that because the employee was terminated after such a short period of time, he would have to explain to prospective employers why his length of service was so short. And this would likely make it more difficult for him to find alternative employment. So the employee was awarded 5 months of notice after just 5 months of employment. And the last case here, which I'll go through very quickly, is a decision of Steele and the corporation. So this case relates to successive fixed-term contracts. Now, generally, courts have held that successive fixed-term contracts, could be indicative of an indeterminate employment relationship. So they've construed a series of fixed-term contracts as an indeterminate employment relationship and awarded employees reasonable notice. In this case, however, the court actually enforced the fixed-term agreement. So it just goes to show that, if properly drafted, an employer can maintain flexibility through the use of successive fixed-term contracts. So the next development that I'm going to speak to is that courts are more closely scrutinizing the manner of dismissal. So as I mentioned before, employers who are wrongfully or constructively dismissed, they could be on the hook for moral and punitive damages. A number of recent decisions from the Ontario Superior Court just highlight some of the conduct that courts will assess in awarding moral and punitive damages. So in this Griffin decision, for example, the employer's conduct was particularly egregious. So they launched a frivolous counterclaim against the employee to intimidate them. They, made up all these allegations of fraud that, were completely baseless. And so the court awarded $75,000 in punitive damages to the employee because of this conduct on the employer's part. And in the Telger decision, the bad faith conduct was less severe. So for instance, the employer was late in issuing the termination pay, didn't provide a written notice of termination and so forth. So they didn't meet their sort of administrative obligations under the ESA, and they were awarded, they were required to pay 15 grand in moral damages to the employee. And then just a quick point at the end there, the duty to act in good faith applies both during the employment relationship and after. So an employer's bad faith conduct throughout the course of litigation could be used against them and used as a basis to award moral or punitive damages against them. So I'm going to discuss the takeaways now. With these trends and developments in mind that I just discussed, we've identified several key takeaways to mitigate risks related to terminations. The first is to update employment agreements and related documents. What I mean by related documents is workplace policies, group benefits plans, incentive compensation plans, and fixed-term contracts. So anything really that speaks to an employee's entitlements on termination. These should be updated periodically. Very frequently there's changes in the case law that could impact the enforceability of an agreement. So from time to time, you should have these reviewed. And you should also consider whether it makes sense to maintain a fixed term employment agreement, given the risks involved in doing so. If they're not properly drafted, then, the consequences could be significant. The next key takeaway is to consider an employee's individual circumstances and the timing of dismissal. So as I mentioned, an employee's age, length of service, these sorts of factors will influence the amount of reasonable notice they're entitled to. In terms of strategic timing, if you're terminating an employee's employment just before the holidays or during a global pandemic, for example, these sorts of things are going to impact how long it takes the employee to find another job. So you should keep that in mind, because that could, that tends to increase the amount of notice they'd be entitled to. Third key takeaway is to carefully consider the just cause position and seek advice. So what we very frequently see in our practice is employers tend to jump to the just cause position. They're too quick to assert it. Yes, like in many cases, an employee's conduct will be inappropriate, but to meet the threshold of just cause, it's in most cases, you're not going to meet that threshold. And so, really consider it, appropriately document the misconduct, to make sure you're taking steps to discipline the employee, because without having first taken all these steps, chances are you haven't reached that threshold. The next key takeaway is to conduct terminations in a manner that accords dignity and respect to the employee. So a termination is almost always unpleasant for the employee, and in some cases can be extremely traumatic. So what that means is that you need to handle it with appropriate sensitivity. It's also important to keep in mind that terminations of employment can be very unpleasant for the HR professional or the manager who has to deliver the news of the termination. So it's important to ensure you're planning properly, you're thinking through, logistical aspects of the termination, such as return of company property and so forth, so that you're well prepared for the termination meeting. And the last key takeaway is that employers must ensure they comply with their statutory obligations. So, for instance, paying termination pay on time, issuing the ROE on time, providing written notice of termination, these sorts of things. Because if you don't meet those sort of administrative obligations, then it could be used against you in the form of a claim for moral damages. So that's what I have for those takeaways there. Laura, over to you.
Couldn't find the mute button. That was the delay. Hearing you go through kind of the tips and traps, let's call it, as it relates to terminations and conducting them in a manner that is, mitigates the risks that are evolving. I have so many questions that come to mind with respect to that I know that we should clarify for our attendees and just for employers in general. Because of the timing of where we're at now and wanting to have a Q&A at the back end, I'm going to save one of those questions for you, Faraz, to the end and kick it over to Joel now, who's going to take us home, going through a number of kind of general considerations, tying it together, but also specifically speaking to what has created a really new world order for organizations, and that's our new hybrid working arrangements and specifically work from home. Over to you, Joel.
Thanks, Laura, and good afternoon, everyone. Thank you all for spending your afternoon with us here today. I'm I'm going to just start off. I'm going to say, judging by how many more grays you can see in my beard, if you look at the video as opposed to the photo on your screen, I'm going to be able to say that remote work is not a new issue anymore. But with that said, it is still a hot topic and one that we need to keep talking about because there continue to be developments for employers to stay aware of. So last year, we really began to see a lot more case law for the first time really since the pandemic that help employers understand and ensure that employees are being productive when they're working remotely. And I'm going to speak more about that here today. Additionally, in 2023, more employers began to require employees to return to work after a lot of them tried out more flexible arrangements the first couple of years post-pandemic and started to determine that maybe this wasn't for them. We did see a big trend over these last few months of some employers, many larger employers in particular, expecting employees to come back to work more than they had previously. Now, remote work also creates the possibility for employees to take advantage and in some cases to commit time theft. Now, as I'm getting started here, I do want to note, I don't want to seem like too much of a cynic. Those of you who know me may realize I'm a bit of a cynic at times, but I want to acknowledge that the stats, they show that most employees are just as productive, if not more productive, when they're working at home as when they're working in the office. And so most employees can be trusted to be productive when they're at home, whether you're tracking their hours, monitoring what they're doing or not. But the unfortunate truth is, and here's where the cynicism comes out, it's that there are those rare employees who will take advantage. And as employers, it's incumbent upon you to really make sure that you keep that in mind when you're managing your staff. And so let me kick it off here with some key concepts to make sure that we're all have a level playing field here. So the first point here, employees are required to perform work during working hours, whether they're at work or at home. This seems simple, right? And really there is that general expectation in the law that employees will work during their scheduled working hours. But with remote work becoming more prevalent, it's more and more complicated for employers to know if an employee is in fact working when they're required. So one key issue that we see over and over and over again for managers and for HR professionals when it comes to remote work is sick days. It's becoming more and more difficult for employers to know whether an employee is taking a sick day, whether this is a sick day or not, what have you. So one issue, this can happen for employees who work hybrid or work generally in person but can work at home as needed. If they're not feeling well, if they stay home, it's not always clear to the employer if they're staying home just to not spread their illness, but they're well enough to work and they're still working there, or whether they're staying home and in fact really taking a sick day, but not marking it as a sick day in the system and using up one of those entitlements that they have. For those who work entirely remotely, it's arguably even more complicated. Managers often won't know if an employee is working during the day, especially for those who work primarily independently while also working entirely remotely. So if there's not a system in place to ensure that employees are working when scheduled and mark themselves off when they're sick, it's easy for employees to take advantage. Now, I'm sure this doesn't sound hypothetical to most of you because it really isn't. Just this week, I'm in the midst of supporting a client through an issue where an employee who works remotely and is salaried and works very independently, she was asked recently by her manager about her not meeting her performance metrics. This is a metrics-based role, and so it's pretty clear when the employee is not hitting those targets. And so this employee shared with her manager that she's dealing with a medical issue and it's causing her to need more time to complete her work than normal. Over the course of a few weeks and getting medical information from the employee, waiting for that, having discussions with the employee about their limitations, it became clear that this employee has actually been regularly taking numerous days in a row off work because of this medical issue, but they're not marking it as a sick day. They're not telling their manager. They're just, allowing themselves to kind of stay home, not connect, but not sharing that information and being paid their salary while doing so. And now it's not just sick days that become more complicated when it comes to remote work as well. And for another client I was supporting last Friday, I supported them with an employee who's about to begin a maternity leave. And this employee is planning to take a very short mat leave of only a couple of months. She generally works a hybrid role, a couple of days in office, but she shared with her manager that after this very short mat leave, she is intending to request an accommodation of an extended work from home period where she entirely works from home. Now, important to keep in mind, while this employee works independently, she is required to perform her work at specific times during the day. Sometimes that's to manage clients and present to clients and other requirements that are time specific. And now this employee hasn't shared with her manager, why she wants that work from home accommodation, but based on some informal comments that she's made to others, it's become fairly clear to the employer that this employee plans to stay at home to care for her newborn while working. And, that does create some serious difficulties given the nature of this employee's role for her to meet their expectations. And so this is an issue that the employer is, needing to identify and address. And they really only found out, informally, kind of through word of mouth, that this was what was going on. Now, the next key concept here that I want to talk about, employees do owe a duty of fidelity while they're employed. So the duty of fidelity requires all employees to act in their employer's best interest while they're performing work for the employer. This is similar to the concept of fiduciary duties, which is only for much more senior employees and is a greater obligation to act in the employer's best interest in more circumstances. But all employees have this duty of fidelity, and it does have that obligation to act in best interest of the employer while they're working. So this obligation is really key in these circumstances where employees work independently while they're working at home. And so I'm going to share a couple of cases in just a moment that you'll really illustrate that point for you. Now, finally, employers have an obligation to record employees' hours worked, even when they're working remotely. So generally, employment standards legislation nationwide is going to require you as an employer to track your employees' hours. This is going to be a standalone obligation. This is generally going to exist even if the employee is salaried, even if they're working remotely with minimal supervision. And now, while this is legally required in most cases, tracking employees' hours is also the best way to make sure that your workers are working when they're required to. Now, I'm going to move forward now in the interest of time and start speaking about the developments and trends that I want to cover here. So, last year, there were a couple of cases that really helped shine a light on time tracking software. So time tracking software, employee monitoring software, it can be used both to justify dismissals and in some cases to get repayment from an employee who's committed time theft. And there are a couple of cases here that I want to speak about that help shed light on that. So the first here, the Bessie decision. In that case, the employer installed time tracking software on this employee's computer, and that showed that the employee's spreadsheets that showed the time that they were working were not accurate based on the time tracking software. And so as a result of that, this employee, who did admit that she said she was doing some work that in fact she was not doing, she was dismissed for cause. And so the tribunal that she went to after having been dismissed, they found that she did engage in time theft, and that in addition to that, the employer was entitled to repayment of that money that she stole by stealing time. Now, not every case is going to result in those orders where the employee has to repay the employer. So there's another decision. This one's also out of BC, just like that Bessie decision was, called Trejo. And in this other decision, an employee was not required to record her hours worked, but after the fact, the employer suspected maybe she hadn't been working when she was supposed to. They tried to create a spreadsheet based on software logins and the calendar and different things to show that the employee, in fact, was not working when required. And that employee was dismissed as a result. But in that case, the employee, the employer was not able to rely on that spreadsheet. The court said that that spreadsheet was not reliable, and so the court did not order that employee to repay the wages that the employer felt that she stole from them. Now, the other issue that I want to talk about briefly here is moonlighting. So moonlighting can amount to cause for dismissal. And there's the key case of Dove that you heard Ingrid talk about earlier that really helps to illustrate that point. Now, Ingrid talked about the facts of that case. I won't repeat that, but what's important to understand there is that in that case, the court did find that there was just cause to dismiss an employee because she was spending so many days, so many hours doing her side volunteer role when she was supposed to be performing work and was being paid to work for the employer. And so in that case, the court did uphold, following the investigation that Ingrid talked about, a for-cause dismissal of this employee because she breached that duty of fidelity that she owed to the employer by moonlighting. So I'm going to shift over now and speak about some key takeaways for you. The first takeaway that I want to discuss is that if an employer changes their practices as it relates to flexible work arrangements, consider any promises that were made to those employees previously. I mentioned before, many employers are starting to ask employees to come back to work more than they were previously when they realized the level of flexibility that they were offering doesn't work operationally. And often this comes from a directive from upper management without understanding the potential consequences of that directive. And so, what can happen is if employees may have been hired, during COVID or hired on new employment contracts with different terms over these last few years, these contracts may offer more flexible working arrangements than upper management now intends to offer to these employees. And so where these employees do have this contractual right to a certain level of flexibility that is being taken away by the company, that in many cases may amount to constructive dismissal and create huge exposures for the company. And so for HR professionals, for managers, it's really important to make sure that, when these decisions are being made at a management level, that management understands what types of contracts there are in place and what types of liabilities that may create for the employer. In addition to that, I really want to make sure you leave here today and you understand that you need to make sure that your employment contracts require that employees track their hours where they're working from home and the employer doesn't have another way to track hours. And you need to ensure that you're reinforcing this in your policies and you're routinely checking records. So make sure the contracts have that language requiring them to track their hours. Make sure that your policies or your work from home agreements, that they really make it clear to the employee how they're supposed to track their hours, what systems they're supposed to use, how they're supposed to report that to the employer. And then in addition to actually requiring that in the policies, make sure the managers understand that they're expected to audit that on a regular basis, that they're expected to look at that and monitor where employees are working to make sure that they're, the employer is able to take whatever steps are necessary where the employee may not be working where they're supposed to. Now, the last thing, if you are going to use time tracking software, you really want to be mindful of privacy and monitoring requirements. So in Ontario, most employers would know if you're provincially regulated, you need to have an electronic monitoring policy if you have 25 or more employees, and that's where you would address any monitoring software that you use. For federally regulated employers, I should say, along with those in Alberta, with those in BC, those in Quebec, there's provincial privacy legislation that you need to make sure that you're complying with. And I mentioned before from the Dove decision, Ingrid spoke about it as well. Make sure that you investigate any allegations of time theft or moonlighting, and make sure you give the employee a chance to respond to those allegations before you act, before you dismiss or bring a claim for repayment or whatever the case may be. So I tried to go through as quickly as I could there, and that brings me to the end of the remote work section. And so before we get over to the Q&A, I just want to very briefly put on your radar for those who may not have seen it. We did send out our annual year in review webinar just a few days ago, and so that should have been sent to you if you're on our mailing list. That newsletter, we've made it more digestible than ever this year, but we also linked to blogs that provide a lot more detail for you if you need it, to really make sure that you can understand all these issues that we've talked about and more. There's more information in there about WSIB, more legislative developments that needed enough time to get to today, and some others that you should make sure that you're aware of. And then finally, I'm very, very excited to announce that our annual seminar that for many, many years before COVID was in person, but we had to shift to virtual as a result of the pandemic, is going to be coming back to in person this year. And so please save the date for our 12th annual Proactive Workplace Law Seminar on May 30th of 2024. More details to come for that, and we hope to see you there. So with that, I'm going to ask all the other speakers to join me back on screen and pass it over to Laura to bring us through some Q&A.
Thanks so much for that, Joel, just walking us through our new times in terms of, and the implications of how we're now working, including in a hybrid manner. So, in the interest of getting through the questions that have been asked, because we have many and we have very little time, team, I'm going to ask you as you come back on camera, everyone, to just, as quickly as you can, pepper the answer. I'm going to try to get through, so I'm going to do a really kind of quick round robin on some of the questions that we can cover. And I'm going to start with a question related to accommodation for you, Alex. And no surprise, there are a lot of questions around meeting accommodation obligations. The first one is, are there items you see missing in organizational policies regarding accommodation?
Well, the rapid answer to that, Laura, is yes, policies. I mean, first, we find that a lot of organizations don't have an accommodation policy at all because it's not technically legally required. Although if you don't have one, you can be found to have not sort of demonstrated a commitment to accommodation. But other than that, it's those pieces that I talked about really setting expectations for the employee about their role, the fact that they have to cooperate, what kinds of things, not in super detail necessarily, but what kinds of things might they have to provide you, and what kinds of things could you ask them for? Those would be the highlights.
I'm going to stick with you for a moment, Alex, and ask you this one. Would we be wise to have employees sign off annually on the accommodation policy specifically, or as part of a health and safety policy?
If that's a practice that you've generally had, I think it's a good one to bring these things to employees' attention. If you haven't had them sign off previously, you always have to wonder practically, from a business perspective, is this going to set off their antenna and they're going to wonder, well, why now? So often when you're trying to get employees to acknowledge this, it might be good to pair it with a training. If you haven't had one for, health and safety obligations, if it's part of your health and safety policy or program or procedures, or for training for your frontline managers on things that they should be doing, how they should be responding for things. So that might be a way to get an acknowledgement as well.
All right, thanks for that, Alex. Nee, I'm going to move over to you. These ones may be true quick quickies. First one, how will we verify recruiters are licensed?
Absolutely. So as I mentioned, employers can speak directly to the temporary help agency or recruiter and ask that way, but they can independently verify whether the recruiter or a temp agency that they want to use is licensed, and they can use the Ministry of Labor's online portal. I can just drop that into our chat for our attendees.
Perfect. And then just a second, there's another one here for you, and that is regarding the salary ranges being posted. Is it expected that we post the minimum, mid, and max range of the job, or may we post the hiring range only?
Good question. So as I mentioned, the bill is in its second reading. So far, what they're asking employers to do is post the expected compensation or the expected range of compensation for that particular position. But they also say, more to come with respect to certain conditions, expectations, restrictions that are going to be prescribed. So the answer is, look out for the development to know for sure the exact specifics.
All right, thank you for that, Nee. And Ingrid, there's one here for you, and that is, if I can get to it, it is, do you have a template to guide the investigation process?
So I believe I've answered that just through the chat box. I've linked to our fall 2023 newsletter. There's a very helpful article in there called Anatomy of an Investigation. Really proud of that title. I think it's cute. That's it gives a very good overview of the investigation process and some of the pitfalls you need to look out for. And I believe the link is in the chat box, but if it's not viewable to everyone, we can distribute it more widely after this presentation.
All right, thanks for that. There is another one related to workplace investigations that I'm going to just tackle because I don't want to feel left out. It's for workplace investigations. As a lawyer, I find client mandate includes whether the respondent violated any statutes. This is legal advice and makes me a potential witness. So as a lawyer, if mandate goes beyond simply assessing credibility and getting the facts, I need to decline to take the matter on. Thoughts? Well, one of the things I'll just say quickly is making legal determinations as an external investigator, because that's the lens that I'm taking the question from. There's nothing improper in that. I mean, what you want to make sure is that, there is very clear role distinctions, particularly where there could be a lawyer that's actually advising the organization. So between that counsel and you as an external investigator, make sure the roles are clear. You make sure in the terms of reference related to the investigation process, as well as in the investigation report, that it's specified that you're not a lawyer or counsel for the organization. And these are ways that you can avoid any type of kind of enmeshment in becoming a witness or your role being questioned. And again, one of the things that we do very clearly to make sure that we don't run afoul of this is we also don't refer to the organizations that we conduct investigations for as clients. We refer to them as the organization, even if they're footing the bill. And that's really important too, because if they're actually clients, then we do have obligations to act in their best interest, which compromises our impartiality. So I'm hoping that answer helps to kind of give you some sense of how they resolve that. I'm going to move to you, Faraz, and I'm just going to ask you a global question because as you identified, terminations and employers making termination decisions are increasing. And if you can, as succinctly as you can, what would you say are the chart toppers with respect to issues that employers sometimes unwittingly create for themselves in how they conduct terminations?
So I'd say one of the most significant risks that employers create for themselves is not taking sufficient documentation to support the termination. So employers often don't adequately document performance issues or disciplinary actions and so forth. The next one would be employers failing to apply policies and procedures consistently, which is key to support certain decisions. And the next one is where employers, they inadvertently violate employment laws. So I spoke to this earlier. That's where they're not issuing termination pay on time and issuing ROEs and so forth. And the last most common one that I see is ineffective communication with employees around the reasons for termination. So, when you do that, if it's a without cause dismissal, for example, you don't want to provide specific reasons for the dismissal, especially not performance-related reasons.
Thanks for that, Faraz, and thanks, team, for just the brilliance in putting your content together and for just ensuring that we hit the hottest of the hot issues for attendees as they kind of navigate and chart through the difficult issues, but also the opportunities that our new times present. I know that we didn't get to all the questions, but what we will undertake to do is when we send out post broadcast the deck, we always send out the deck, we'll also answer some of the questions as long as they're not written in a way to solicit legal advice, because we will not provide legal advice, but we will provide you with answers to the questions that we couldn't get to out of our ambition to provide you with as much content during the time that we have. But being respectful of your time and knowing that we all have competing priorities, and also appreciating the time that you've taken to join us today, we will end here. And we thank you so much again for joining us. And please feel free to reach out to any of our lawyers if you have questions regarding any of the themes that we covered or other issues that are impacting your workplace. And just wishing you, given that we are at the start of the year, although it's moving quite quickly, an awesome 2024. Thanks for joining us.